In the immortal words of Monty Python, and now for something completely different. It's a delight to be here. Susan, thank you so much again. The last time I was here, I talked about Bob Dylan.
Yes.
And we had fun.
And you helped him get the Nobel Prize.
And I helped him get the Nobel Prize.
We helped him get the Nobel Prize.
Now I want him to help me get the Nobel Prize. Is that right? I know I'm the last man standing between you and a wonderful dinner. So I will try to keep this direct, cogent, etc. When we talked, Susan, the question was, in history, judgment is all over the place. So the question was, where was I going to settle down? And you said, well, look, you can do anything from Bob Dylan, which I didn't want to do again, to current American politics. And the question about judgment in American politics these days is really problematic. So I decided to talk about misjudgment instead. And particularly to talk about the concept of originalism, which is something that some of you may have heard of. It is now the regnant judicial theory in the American federal judiciary, at any rate. And it's just very, very important. And it's important, I think, not only for Americans who don't really understand what it is, but also for all the rest of you, because it's not going to come in the same way, but something like it is coming. So, I'm going to begin with a little story. Nothing all right?
Yeah, no, I just want to give you some
Okay,
light.
great. Okay. Last fall, a man named John Badalamenti was an adjunct professor at the University of Florida's Law School, the state of Florida's most prestigious law school, who also happens to be a Donald J. Trump-appointed judge on the U.S. District Court of Middle Florida, evidently a figure respected by liberals and conservatives alike. Last fall, he awarded a not particularly prestigious but still special prize to a student, an unashamed anti-Semite and white nationalist named Preston Lansky, in recognition of a paper that argued, among other things, that the framers of the U.S. Constitution intended their preamble's phrase, "we the people," to refer exclusively to white people. That the 14th and 15th Amendments, which protect equal protection under the law, birthright citizenship, and the voting rights of non-white citizens, are likely unconstitutional. That the Constitution regards all aliens as, quote, second-class persons, and that the, quote, criminal infiltrators at the border ought, on strictly constitutional grounds, to be summarily shot and killed. Should the United States government fail to follow the Constitution's mandate for a white ethno-state, this paper concluded, the people will be justified to rise in revolt and settle the matter not by the careful balance of Justitia's scales, but by the gruesome slashing of her sword. He's got an award. Predictable, confused, and confusing turmoil erupted, worthy of bonfire of the vanities, right? Everybody talking by one another. Outraged students and faculty naturally condemned an award being given to a person who once said that it would not be manifestly wrong to call him a Nazi. Administrators, however, defended the award on free speech grounds, and while also citing the principle of institutional neutrality, whereby academic institutions are supposed to refrain from taking public positions on virtually any hot-button issue. In opposition, a black visiting professor from Southern Methodist University, citing her own troubles at that law school, declared, quote, "We should not be giving awards to things that advocate for white supremacy and white power." In response to that, another professor countered that it would be, quote, "academic misconduct if an instructor who opposed abortion rejected a well-argued paper advocating abortion rights, so it would be a misconduct to belittle a well-argued white nationalist paper." The libertarian magazine, Reason, weighed in with a spirited defense of the judge as a man who was the furthest thing from a white supremacist who had no way of knowing that the student was a Nazi. In fact, he only really revealed himself as such a little bit later on formerly known Twitter. Moreover, the magazine argued, the paper was technically strong and well-versed in current scholarship. And besides, William Lloyd Garrison believed that the Constitution as originally written favored white people. Quote, "There is a scholarly debate in this area," the article said. It failed to mention that the most consequential defender of the claim that the Constitution not only favored whites but established slavery in national law was not William Lloyd Garrison but John C. Calhoun. In fact, of course, this controversy had nothing to do with free speech. It had nothing to do with institutional neutrality. It had nothing to do with academic freedom. Neither does it have much to do really with whether the judges are racist, nor for that matter does it have all that much to do with the student Preston Lansky's racism. It's rather a matter of judgment. That is, by what lights could a federal judge, in his role as a professor, consider Lansky's paper so well argued that it deserved an award? At the most fundamental level, the paper's conclusion appears to revive and perhaps update Chief Justice Roger Taney's longest credited ruling in the notorious Dred Scott case of 1857 that blacks had never been citizens of the United States and thus had no rights that a white man was bound to respect. A ruling that Abraham Lincoln famously declared that was, quote, based on assumed historical facts which were not really true. The paper evidently also ignores how the revolutionary abolition of slavery by constitutional means, after a long war, with the 13th Amendment necessitated the adjustments of due process and citizenship in the 14th and 15th Amendments, both framed and ratified in accordance with the framers' specifications, and therefore by definition constitutional. By what logic, what method could a paper contending otherwise be judged well argued? Well, barring public release of the paper itself, and as far as I know, it's never been fully released, the main clue to answering that question is in the context. Because the student, Preston Lansky, wrote his paper for a seminar on the now dominant doctrine of originalism, with a lead instructor who was also a member of originalism's greatest institutional proponent, the Federalist Society, all deploying originalist reasoning. My point is not that originalism is inherently racist. In the wake of the controversy, in fact, a colleague, one of originalism's foremost critics, Jonathan Gannap, noted that the originalists mostly argue that the Constitution, quote, tilts towards liberty, and that in that case, that the post-Civil War amendments, quote, washed away whatever racial taint marred the original document. My point has to do with the student Lansky's deployment of originalist methods, backed, according to Reason magazine, whose writer apparently saw the paper, backed with abundant originalist scholarship in ways that sufficiently impressed an originalist federal judge that he would deem it worthy of any kind of accolade. Perhaps the judge, no matter how intelligent, simply exercised poor judgment. There is, though, I think, reasonable cause to believe that the madness resides in the easily manipulated originalist method itself, a method that purports to absolute neutrality and that today dominates how the US federal bench interprets national law. If originalism, strictly adhered to, could produce a violent white nationalist reading of the Constitution that is at least plausible to a federal judge, what can't it do? And that is precisely the reason why the otherwise trivial matter of a student paper is grounds for concern. The originalist slope, it seems, is getting pretty slippery. Originalism's influence, once confined to the nation's law schools, is now vast. First and foremost, at this moment, originalists provide the intellectual underpinning for Trump's emergencies. His lawless assault on law firms, universities, the Smithsonian Institution, the Library of Congress, the Voice of America, and indeed the entire civil service. The grand alibi comes in the form of what originalists present as the doctrine of the unitary executive, a contrived theory of their own making that they pass off as something the framers of the Constitution inscribed in the Constitution. In justifying Trump issuing executive orders as though they were dictatorial decrees, the theory denies innumerable vital federal agencies and institutions, some of which were established by Congress, not the White House, the slightest autonomy, allowing the president more power to remove officials from independent organizations and cloaking the predetermined result in flimsy originalist explanations. The basic conceits of originalism are deceptively simple. To an extent, they batten on, at least until now, the imperishable centrality of the Constitution itself in a 250-year-old constitutional democracy. But whereas the framers' words have always been the foundations of constitutional interpretation in the United States, originalists have added a kind of scriptural fundamentalism, asserting that the meaning of the Constitution's text was fixed, knowable, and unambiguous at the time that it was written, and that this meaning should govern for all time. To these absurd presumptions, the originalists add one more, that only originalists can divine the framers' meaning and then dictate what the law says. The originalists claim that they are serving a truly impartial jurisprudence, merely calling balls and strikes, as Chief Justice John Roberts' phrase has it, based on a literal meaning of the Constitution. In fact, the record shows glaringly that the originalists work backwards from their goals to find the magic words to cloak their extremism. Facts and precedent be damned. Originalists bully their way forward using distorted and outright fabricated history, figuring that no one will call them out. And no one ever does. No one ever has, until very recently. Then they turn their glaring historical misjudgments into historic rulings. Whatever its claims to historical grounding, originalism is a comparatively new invention as a faux judicial theory. It began life as a direct political response to the US Supreme Court's landmark 1954 decision, Brown v. Board of Education, that declared racial segregation in public schools to be unconstitutional. The Brown decision, was an affront not just to Jim Crow Southerners, but to the broader conservative movement, exemplified by William F. Buckley Jr.'s then new magazine, National Review. There's direct root from the segregationists' arguments against civil rights to Chief Justice John Roberts' originalist ruling in the case of Shelby County v. Holder in 2013 that eviscerated the Voting Rights Act of 1965. It's important to note that this reactionary movement was not confined to the political fringe. The spirit of constitutional originalism had existed for many years, focused mainly on opposing the reforms of the New Deal. Having switched to responding to desegregation, though, the movement conservatives suddenly had to obfuscate the racist core of their position. Concealing their bigotry in the folds of history, they embarked on supposedly discovering the original intention of the 14th Amendment. Original intentions they contended would show that equal protection under the law, as guaranteed by that amendment, was irrelevant to securing civil rights for black school children and their parents. To undermine the Brown decision, conservatives hit upon a slogan that they dressed up as a judicial principle called intent construct. This was the first definition of what became originalism. To distract from the racist foundations of their resistance, they tried to shift attention from existing injustice to what the framers of the Constitution supposedly intended, the intent construct. As a leading pro-segregation journalist, and most of this came actually not from judicial scholars, but from journalists, from political activists, actually. As James J. Kirkpatrick wrote, quoting constitutional cases, the clock must always be turned back. Opponents of Brown, most notably that same guy, Kilpatrick, originally relied on the states' rights notion of interposition, that a state legislature could interpose itself to thwart federal law. But that got nowhere. And when that got nowhere, they shifted from interposition to original intention. With the seed planted against desegregation, the conservative movement nurtured and grew the project of what became known as originalism. For example, what became the Bible of movement conservatism in the United States, Barry Goldwater's book, Conscience of a Conservative, published in 1960, although in fact written by Buckley's brother-in-law, Brent Bozell, stated what was becoming a right-wing commonplace, that the Brown v. Board of Education decision violated, quote, the intentions of the Founding Fathers and the intentions of the 14th Amendment authors as well, neither of whom intended to outlaw segregated schools. It was not on James Madison's mind. The most important figure in refining these arguments and then defining them as originalism was a man named Robert Bork. Anybody here remember who Robert Bork is? Some of you don't remember Robert Bork. Okay, Robert Bork, who, as Richard Nixon's acting attorney general, tried to suppress the Watergate investigation in the notorious Saturday Night Massacre, in which, on President Nixon's orders, he fired the special prosecutor in 1973. A very savory guy. Bork had proposed 2 years earlier what would become an influential outline of originalism in an article for the Yale Law Journal. He argued that the judges should be able to discover what the framers actually intended from, quote, text or history without inserting their own interpretation. So this is, purist fundamentalism is what he's preaching. Funnily enough, in Bork's originalism, the framers always supported what the contemporary right wing wanted at any given moment. When President Reagan nominated Bork to the Supreme Court in 1987, the Senate rejected him as too extreme. Yet if Bork's nomination failed, the ideas he propagated had already gained momentum. In 1985, President Reagan's Attorney General, Edwin Meese, soon to be disgraced himself in a financial scandal and forced to leave office, addressed the American Bar Association, professing that, quote, the intended role of the judiciary was to serve as, quote, bulwarks of a limited constitution. Judges and justices, he argued, should be expected to, quote, resist any political effort to depart from the literal provisions of the Constitution, and, quote, press for a jurisprudence of original intention. Meese and the originalists concealed that the original intention meant intention as construed by themselves, the originalists. These ideological inventors left unstated the inconvenient fact that the framers of the Constitution itself themselves believed that the Constitution's words should not become a kind of scripture, but instead serve as a basis for guarding freedom and rights while pursuing in the preamble the general welfare. There isn't actually a positive aspect to the Constitution which people don't recognize by not always reading the preamble, where it's there, under the general welfare clause. That's what they intended to do, though, but see it as a guide, not as a holy scripture. The framers endlessly disparaged the idea of an unchangeable fundamentalist text. Quote, in framing a system which to last for ages, we should not lose sight of the changes that the ages will produce, James Madison said during the Constitutional Convention. In a debate at the House of Representatives on April 6, 1796, Madison declared again, quote, whatever veneration might be entertained for the body of men who formed our Constitution, of which he was one, sometimes thought of as the father of the Constitution, whatever veneration might be entertained, the sense of that body could never be regarded as the oracular guide in expounding the Constitution. But the originalists ignore the practical sense of the framers as they claim to conduct seances, hearing their voices from the beyond. Antonin Scalia, appointed by Reagan to the Supreme Court in 1986, became originalism's most visible and vocal proponent on the court. Originalism also became the creed of the Federalist Society, which I mentioned earlier, an organization of conservative academics that morphed into a hugely influential elite right-wing legal and political operation, grooming hundreds of lawyers for appointment to the federal bench, a vast machinery to take over the judiciary and the law. In 2000, in one of the crudest but most consequential maneuvers in American history, Scalia led a conservative majority on the court in a 5-4 decision to hand the presidency of the United States to the Republican candidate George W. Bush by stopping the counting of thousands of ballots in the Florida contest. Scalia, in a bit of originalist jujitsu, flipped the 14th Amendment's Equal Protection Clause to declare Bush the winner. A ruling that Scalia reportedly confessed in private later was, quote, as we say in Brooklyn, a piece of shit. Over the decades since, a dedicated and staggeringly well-funded movement of plutocrats and their right-wing allies has worked through shadow networks to capture and politicize the courts. And someone was asking me about where this all started. It goes back to the 70s and well into the 1980s, but it really accelerated thereafter. How much money was involved in all of this? Probably more than $2 billion. According to Senator Sheldon Whitehouse from Rhode Island, this operation spent $34 million alone in the campaigns against President Barack Obama's choice of the Supreme Court, Merrick Garland, and to install the originalists, Neil Gorsuch and Brett Kavanaugh, on the court. That's been money well spent in the right wing's dark money operation. It's won victory after victory in the courts in every domain of law, from gun rights to abortion rights to environmental law and beyond. The real trick for the originalists is to find language that is roomy enough to embrace their prearranged goals, but also narrow enough to avoid sounding obviously contrived. Contrary to the humbug of what originalists would have you believe, the founders did not have a unified vision. Madison believed that even the meaning of words in the Constitution acquired different definitions over time. Quote, what a metamorphosis would be produced if the code of law in all its ancient phraseology were to be taken in its modern sense, he stated in 1824. But it's easy enough to manipulate historical-sounding language into a single, clear-cut original meaning, and then arrive at an interpretation of that meaning that justifies the desired conclusions. Intended to have a gravity not unlike fundamentalist biblical exegesis, it more closely resembles three-card Monte, which it's like a shell game, okay? That's what it resembles. Such historical distortion and falsehoods, for example, form the cornerstone of the court's decision in Dobbs v. Jackson Women's Health Organization, the case that eliminated federal protection for abortion rights. Among the central assertions in that decision, written by Justice Samuel Alito, concerned what Alito called a most important historical fact, that 28 out of 37 states banned abortion throughout pregnancy at the time that the ratification of the 14th Amendment, which was the basis for Roe, was ratified in 1868. That came down with the decisions. Historians quickly but futilely noted that Alito's claims were spurious, that at least 7 of the 28 states he claimed had completely banned all forms of abortion actually permitted them in some form or another. Roe finally fell in 2022, a victim of bad faith originalist history, and women were deprived of a basic right to reproductive freedom and health. As in 1857 with the Dred Scott decision, the case turned on assumed historical facts which were not really true. Alito was not alone on the Supreme Court bench in warping the historical record. At this point, one critic observes, distorting the past, quote, distorting the past to further his ideological agenda has become the trademark feature of Justice Clarence Thomas. Thomas's majority decision in the case of New York State Rifle and Pistol Association v. Bruin in 2022 struck down a New York law that required persons to obtain an unrestricted license to carry a concealed firearm. The defense, along with amicus curiae briefs, cited numerous Reconstruction-era regulations as precedents of the regulation law. There's plenty of examples of it from the Reconstruction period. Thomas dismissed these outliers and placed far greater weight on how, he said, English peasants during the 1500s carried guns. Now English highwaymen in the 16th century were as good as the framers for originalist precedent. He really says this. I mean, it's just shameless. Thomas's decision rested on Scalia's originalist formulation in District of Columbia v. Heller in 2008, in which he extended the Second Amendment guaranteeing the right to firearms, which applied to members of the militias in those days, what is today's National Guard in the United States, to an unqualified right for gun ownership for every individual. This is originalism with a vengeance. Thomas, however, took it beyond all hitherto limits, claiming that any and all gun control had to be able to cite an analogy to a regulation on an originalist basis to be valid. If there wasn't a law there in 1787, you couldn't regulate it. Time does not march on. In the case of 303 Creative LLC versus Salinas, the Supreme Court showed just how far it was willing to go in ignoring the facts and ignoring history by fabricating the recent past as well as the distant past. The majority ruling, written by Justice Neil Gorsuch, held that a wedding website designer was entitled to discriminate against a gay couple because the Colorado law which prohibited her from doing so violated her First Amendment rights. There's ground for arguing about this, actually. I mean, Albie brought it up before. I mean, what happens when you have conflicting religious ideas? Do you want to own them? How are you going to handle it? That would have been an interesting debate to have. The problem was that the entire case was a scam. One day before the court's opinion was published, the New Republic reported that the facts had been completely fabricated. The designer that had never been asked to make a gay website, the religious right had engineered the complaint in order to bring a test case to the Supreme Court. Gorsuch's ruling, meanwhile, rested on another assertion of false history. That, as he put it, religious speech had always occupied an unimpeachably privileged position in American law. With that, he stomped on the principle of the separation of church and state fervently advocated by James Madison and Thomas Jefferson, and which is enshrined in the Constitution's Establishment Clause prohibiting government support of religion of any sort. The so-called Trump disqualification case. I could go on for a very long time. I'm going to spare you, but just give you a couple of examples. The so-called Trump disqualification case, Trump v. Anderson in 2024, saw the court gut the 14th Amendment's barring of anyone engaged in insurrection against the United States, whether or not convicted of that crime, from holding federal or state office. The ruling was a disgrace on several grounds, not least that the three liberal judges went along with a wholly invented claim that the individual states could not bar insurrectionists. No, so that the individual states could bar insurrectionists, but only from state office, not from federal office. But even the honeyfuggled minority eviscerated the majority's rewriting further on in the decision of a vital section of the 14th Amendment, which, like the other post-Civil War amendments, stated that, quote, Congress shall have the power to enforce that amendment, quote, by appropriate legislation. With incredibly cherry-picked, indeed truncated, just not leaving out half the sentence, truncated quotations, the majority twisted this to mean that only when Congress passed enabling legislation would the amendment go into effect. What does that mean? Congress can nullify any constitutional amendment by not establishing legislation, enabling legislation. It's absurd on its face. But it certainly was going to protect Donald Trump, given the fact that the Republicans owned both the House and the Senate. This is very, very strange and very, very dangerous. To be sure, the court majority does not consistently rely on originalist claims. No false history could be drummed up to justify the most egregious decision thus far by the John Roberts Court, the immunity decision in Trump v. U.S., this is from last July 1st, handing the president presumptive immunity from criminal prosecution for what it deems official acts, a category so capacious as to place the president of the United States alone, the president alone, above the law. Although some roughly originalist citations turn up in yesterday's ruling on federal court injunctions, they do not appear to have been the crux of the decision. Where no originalist case can be made, or when originalism is not necessary, the court finds other methods, including in the immunity decision outright invention. It's that cynical. It's that cynical. Originalism has become a powerful tool and has succeeded in insinuating itself into law and politics at every level. It has been featured in every Republican Party platform from 1992 to 2016, except once in 2004. At least 5 of the 9 Supreme Court justices explicitly espouse it, and the rest are required to engage it as a legitimate legal theory. It has taken hold everywhere, from the courts of appeal to state courts, through appointments of right-wing judges. By now, anyone paying attention to American civic life knows about Project 2025. Despite Trump's absurd idea or claim that he was not involved with the project and knew nothing about it, many of the major policies that it describes have been implemented already by the Trump regime. I don't call it an administration, I call it a regime. Since January, or in the pipeline. Many of the contributing authors of Project 2025 are originalists, and the fingerprints of originalism are everywhere in this plan, everywhere. Which makes sense, because Project 2025 aims to remake the whole of American law, politics, and social life in a radical, actually Christian nationalist right-wing mold. Well, it's not completely bad. It's not completely bad. Why? Because at long last, some resistance has begun to cut through the fog of originalist propaganda, too often taken at face value in news reporting and public debate. If you read the New York Times, if you read, certainly on any of the television stations, originalism is taken as a legitimate theory. It's not a legitimate theory, but it's taken that way. And it's taken a lot of effort to try and cut through the propaganda. Among several efforts, there's a thing called the Court Accountability Project, the Brennan Center at NYU, one that I'm involved in called the Court of History, has begun to expose the originalist fraud through news articles, webinars, and conferences. Since the 2024 election, we've expanded the mission to address the illegalities and unconstitutional outrages of the Trump regime, and we've extended our reach to become a podcast. This is the little thing I'm involved in, on a thing called the Legal AF Network. But this is less than a pinprick against the 40 years of originalist propagandizing with the billions and billions of dollars behind it. And for that matter, no matter what happens, what becomes of the Trump regime, which I'll be happy to talk about, it will take much more work before the curse of originalism, which is larger than Trump, and the hegemony of historical misjudgment is dispelled. And so, and I'll conclude with this, starting at the furthest fringes of the segregated South and right-wing radicalism in the 1950s and 1960s, originalism is at the center of the MAGA project. Far from an abstract game of legal reasoning, it has real and devastating consequences. Donald Trump has become the essential implementer of the 2025 game plan to continue packing the courts with originalists like Judge John Badalamenti. But as the United States approaches the 250th anniversary of the American Revolution, we can only wonder what bizarre twisting of history the originalists will invent to justify a truly tyrannical regime. That an originalist federal judge could admire the originalist constitutional reasoning of a white nationalist anti-Semite in favor of a white ethno-state America could very well turn out to be an isolated, insignificant one-off. But so long as purposeful historical misjudgment remains the core of what purports to be American jurisprudence, it's no certain thing. Thanks.
So there's so many questions. I think visually I may not have kept up entirely, so I'll ask for another raising of hands in a minute. But a quick clarification that I wanted to ask for, which is, you talked of originalism and fabricated history. do we have a concept of historical truth in history versus a concept of historical truth that we need for law? Because we seem to have been a bit shaky on historical truth in history. And then coming back to that alongside the idea of the question of fact being indeterminate also for the right wing.
Yes, yes.
Then how do we ground any of this? Do we have a theory of historical truth?
Well, that's a good question. I mean, there is a distinction that American historians often make between history and law office history. And law office history is instrumental, has a very, oh, I'm sorry, can you hear me all right? The distinction between history and law office history. Law office history is instrumental, it has an idea what it wants to do, and in a sense, originalism is a version of law office history. The difference is the theory that somehow the Constitution operates in a particular way. That's dangerous, because it is simply not the case, and it gives license to be able to invent anything you want. Now, on the question of fact, you know, I mean, I'm not going to go into all of the postmodern ways, the way in which postmodernism has become Trumpian, because there is no reality. There's nothing but power anyway, so right? Nevertheless, there's a difference between some states having abortion laws and some not in 1868. Mm-hmm. You know, that's the fabrication that occurs all of the time. And the truncated quotations. And the systematic, it's systematic when they go about doing this. That's, I think, the thread. So I don't think these people care a fig about history. They don't care about history. They care about getting their agenda in. It's all prearranged. They know what the decision is going to be before they start. But they find enough stuff out there in the name of original intention to be able to justify it, which gives it a kind of faux authority.
Peter?
There seems to me two elements to the argument that you made.
Right.
The first is that there's a huge amount, $30 billion more maybe, that's put in through dark money that fuels a Christian nationalist vision of what America should be. And there are various ways that they've argued for it. For instance, when Alito flies the pine tree flag,
yeah.
Or they have a kind of Dr. Strangelove Hitler salute, or talk about anti-Marxism,
yes.
And how the Biden administration are full of Marxists.
Yes.
So there are varieties of ways of justifying it.
Yes.
Then there's the specific discussion, which I also found very persuasive, about their instrumental and inauthentic appeal to this confected originalism, which they apply in a cherry-picking way, as you point out.
Right.
Is the cherry-picked, confected originalism a kind of racing stripe on the card, as opposed to the engine, which is the $30 billion, and the Federalist Society backing? And
I would say,
that is to say,
yeah, I get it.
Who's it for?
Yeah.
I mean, it's not convincing the Democrats, right? So if you have the raw power to drive this through with a bunch of, everything from the Koch brothers.
No, I get it. I get it. You're not going to get very far just with the engine. And originalism is more than the racing stripe. It's the automobile. It's the thing around which the engine must go and in which they can travel. And they've bought the car and they've invented the car. This goes back a ways. This did not just begin very recently. I mean, it really begins in the early 1970s when a Supreme Court Justice to be named Lewis Powell basically said, we have to do all the things the liberals have been doing since 1933. We have to construct our own counter-government, our own counter-establishment, and they started doing so. And in the 80s, the courts became the place that they went for. And that's where the Federalist Society came in and so forth. And they gathered the money from the rich guys to say, this is how we're going to do it. We're going to do it by capturing the courts. So it's, it's synergistic. I mean,
so the lawyers talk about the but-for clauses, right?
Yeah.
But for originalism, would they not have been able to drive this through?
I don't think it went anywhere near as effective. I think it's been extremely effective in the last. Now, court decisions are court decisions, and originalism is not the only thing out there. I want to make that very clear. So, but on any number of things, like the Dobbs decision, I think that without the originalist rationale, they never would have been able to justify it. Because what it does is it's destroying stare decisis. It's destroying precedent. It's destroying hundreds of years of Anglo-American jurisprudence. It's that radical. because it takes what we take to be precedents, or going back to the people refer to the Constitution all the time, but they've destroyed that. You see, so I think that yes, I think that it's been very, very nefarious. Now, I don't deal in maybes. Could they come something else? But this has been very effective, and it's been central, and it's been consistent.
Amber.
Thank you for that. I work with texts, and I think for anybody who works in texts, originalism is just on the face of it so completely ludicrous and such a non-starter.
Yep.
But I thought, given the American religion and so on, I thought of the Reformation. And as soon as people could read the text for themselves, then we had a complete splitting of views. We didn't have like a single Protestantism.
No.
We had 10,000 Protestantism.
Yeah.
So I'm wondering whether the cheaper way of beating originalism might not be to join it.
That mine's related to this question.
Piggyback.
Thank you. Yeah, I have been thinking and wanting to ask you about the relationship between fundamentalism in originalist circles and fundamentalism in Christian circles. Now, if I know my justices right, I think most of them are Catholics, and Catholics are not originalists. But there's a very interesting synergy between a lot of people who don't know much about the United States, or a whole lot about Israel, do not know, and are always shocked when I say that the largest number of Americans who are behind American Israel policy are not the Jewish lobby, but the Christian Zionists, who actually want to send us all to hell when the apocalypse comes. So
We're a convenient tool for them.
yeah. But so there strikes me, at least structurally, there's a huge symmetry between these rather ridiculous arguments, focusing on original intent in the Bible and in.
Sure.
So, can you tell us a little historically about how this come together or don't?
Well, there's a way in which, and actually Dick Hofstadter did more write about this than anybody. There's an element of that kind of evangelical fundamentalism that is pervasive in American culture generally. And it's not simply, you don't have to be Jerry Falwell or Pat Robertson in order to advance it. So it's out there, it's a precondition, as well as the veneration of the Constitution. And the veneration of the Constitution begins literally the day that it was finally ratified, because there was very little opposition to it, hardly any. So there was this extraordinary consensus, actually, I can't quite explain it, that people were not going to object to the Constitution, they were going to interpret it in different ways. But throughout, the Constitution had this, quite unlike any other, had this kind of glowing aspect to it. Now, could they become, could the hard shell Baptists split from the soft shell Baptists, split from this, one Protestant group after another and do all of that? The problem is that once you start playing their game, they win.
Why?
They win because then they will just say, well, our interpretation is better than your interpretation. You cannot fight it out on their ground, because they will always just be able to say, well, there's two of us fighting and we have the power and we win. So you cannot get at them that way. There have been a number of my colleagues, left colleagues, have suggested that we do this, that we come up with a left-wing originalism, and that we come up with our own vision of what the Constitution originally meant. But you can do that without becoming an originalist, is what I'm saying. You can do that without saying there's a fixed idea of the Constitution. It'd be much more of an activist living Constitution, which is something that had in fact evolved over the years, which is what they're out to kill. We didn't start that way like South Africa did. We don't have that kind of social, this is 1787, right? Nevertheless, if you start playing that game, you will lose, I think, given the configuration of power right now. I get it. Intellectually, I get it. And sometimes I'll even play that game, and sometimes encountering them, it's actually useful to counter the history that way, but not in an originalist framework. In other words, not in the same kind of, construction that they put to it.
Rainey.
My question follows in the same vein. My first reaction as a historian is, of course, outrage at the abuse of history. My second reaction is that history actually is irrelevant. To say that history is relevant is to play into the originalist game.
Yes.
So the question is the alternative framework, you said the living Constitution, is it the spirit of the Constitution rather than the letter of the Constitution? You can see why there might be hesitations about this, because that too could be used by any side. The one argument in favor of originalism is the same argument for sola scriptura, which is it creates boundaries, guardrails, restrictions on the arbitrariness of the law. So it's really important, I think, to be very clear about how the alternative would also have that advantage.
Well, I don't think there's I mean, I could point to a number of texts that you could look to. Going back to Justice Story in the 1830s, there is a developed idea of constitutional interpretation, which is not originalist, it is historical. And it comes in, there are lots of fights within it, right? You're going to have conservative versions of that, you're going to have liberal versions of that. But there's a canon, if you will, of constitutional interpretation, which the law schools used to teach all of the time, and that was the way that it was taught. That's what constitutional interpretation courses were all about. Now, it's this stuff that's coming out, which has nothing to do with that very long Anglo-American tradition of, it's not exactly common law, but you understand what I'm saying. It's presidential law coming out of the Constitution. I couldn't give you an XYZ handbook on how to do that. It's not as simple as doing the originalist thing. But this is a basic assault on that. I'll give you the example. One standard idea in what had been American jurisprudence was the idea of stare decisis. That you do have settled law, and the settled law does have to be respected, and that you might want to interpret it slightly this way, slightly that way, but you don't want to mess around with precedent very, very lightly. This completely undoes that. I mean, Roe v. Wade was settled law, 1973 to 2000, whatever. It was settled law. And yet, in an instant, they were able to undo that principle with originalism. I could go on and list a whole bunch of other principles that it undermines, but these are principles that have developed over a very long period of time. They antedate the American, the U.S. Constitution, and they are recognizable. They were recognizable, and there were all sorts of fights and arguments and so forth. There was one moment, actually, where it came undone, and that is the Dred Scott decision. And the Dred Scott decision was the original originalism. Because what Chief Justice Taney did was to invent something that was not true, which is that blacks were not citizens of the United States at the time in 1787, which was simply not true. Black men voted for ratification of the Constitution in numerous states. It simply was made up. Bad history. But it undid. It was trying to, it had all sorts of political valences. So it can break down. Fortunately, the Union won the Civil War, so we didn't have to quite do that. The struggle did not end then. Reconstruction was yet to come, all of that. But originalism, as formulated in 1857, was going to take another, 100 years plus before, 200 years, 150 years plus before it got anywhere in American jurisprudence. That's what originalism is about. It's as if you had, literally, Chief Justice Roberts has once said, and Chief Justice Roberts, who I've met, is a perfectly amiable, if he was in this room, you'd enjoy him, you'd have a cup. Once said that no Chief Justice of the Supreme Court will ever be John Marshall. John Marshall was the first Supreme Court justice, was highly venerated as the man who established what the court was all about. But no judge wants to be Roger B. Taney. He's sure doing it.
Scott.
Okay. I wholeheartedly agree with your zeal against a lot of the opinions that you talk about, in particular the Dobbs opinion. But I think, on my reading of Scalia, I don't know some of the other authors in the originalist tradition. I'm not sure I ever read, no, I did read the Robert Bork book. I think you're misinterpreting it. And I think there's something more to it, properly interpreted. And I don't think that the problem with the Dobbs opinion is the originalism, but something else. I won't go into that now. But I'll even just quote Scalia. I've got it on Kindle, so it's here on my phone. He says he would prefer the term import to semantic import to semantic intention, because that puts the focus where I believe it should be, upon what the text would reasonably be understood to mean, rather than upon what it was intended to mean. Scalia explicitly rejects what you seem to suggest, I may have misread you, that it's an oracle about what these men wanted to accomplish. That's exactly what he denies. He says the originalism is, look, if the meanings of the words have changed over time, then we've got to go with the original meaning. And the reason for that, and Rainey's point is there's something to it, it sort of gives you something fixed, but it's a democracy argument. That's what was passed. To read something else into the document or to a law would be undemocratic. It would be for judges to say, no, we know that this is what was passed, but we're going to read it some other way. So anyway, I just wanted to see what you thought about it.
What's the date of the quotation you've got?
This is from Scalia's book, A Matter of Interpretation.
Yeah, what's the date? What year?
It was in the 90s.
Okay. Originalism has gone through many, many different incarnations and versions. And there's things called, there's original meaning, there's original intent, original meaning. So now original meaning means you go into all the dictionaries and try to find out what the word actually meant in 1787, right? But it's the same thing. It's the same basic idea, which is that you're going to try to imprison the meaning of the American Constitution in something that existed, or that you say existed, in 1787. So history and tradition, it goes by many names. And when Scalia did that, I remember, he was getting a lot of heat because we were saying, say on. It's not, you can't do that. So he switched. He moved it. Well, I don't mean original intention. I now mean original meaning. And so much. I hope someone will write his biography well one day. But you can see these intellectual moves that he makes in particular because he's the smartest one of them all.
Peter.
I just wanted to say, in response to Amber's question, I don't have the historical memory to cite this. But my belief is that the dissents by Sotomayor and others have confronted originalism, and that she said you say you're originalist, but in Trump versus the U.S., look at the Federalist Papers, look at the No Kings setup, so that actually I think the dissents are framed in often in terms of shaming the majority for pretending to be originalists and ignoring, whatever the clerks have come up with.
I completely agree. But what I will say is that the dissents have gotten much more forceful over the last year and a half. They weren't so forceful, say, 3 years ago. They would point it out, but now they're pointing it out with a vengeance. There's a real, the Supreme Court is so polarized now. But you see it in the dissents. You see it in the dissents yesterday. Where Sotomayor, I can't remember anybody else doing it except in Bush v. Gore, where Justice Ginsburg said, they usually say, I respectfully dissent. She wrote, I dissent. And Sotomayor wrote yesterday, I dissent. And I think one other justice is either Elena or the other. I dissent. So now there's a sense of civility is actually breaking down on the court. It's not good. I'm not happy about it. But you're right. I mean, now it's coming out much more. Although even there, I think it's been a matter of breaking through this propaganda. It's all they're feeding off each other. They realize now that there's a public outcry against this way of doing things. So they're picking up on that, and we're picking up on them, and it's working. But it's working sort of. It's still 6-3.
I don't see any other immediate questions. I had a thought.
Somebody's in the back. Somebody's in the back. We've got a hand up.
I just had one question, observation. What do you think will come of the increasing public skepticism about the court and observance of the court's corruption?
Yeah, I mean, it's something that's, if I was Chief Justice Roberts, I'd be very concerned, because the legitimacy of the court's reputation has plummeted. But that's true for all American institutions of government these days. So, you know, I mean, it doesn't bode well. I mean, I'd much be happier having a Supreme Court which had a high public, you know, approval. We don't now, but it's not necessarily going to lead to a reverse of what they're doing. I think quite the opposite. It's going to lead to more, you know, withdrawal. It's going to lead. It's not going to lead anywhere good.
Here's a question in front here.
Thank you. Thank you for the stimulating paper. Like Amber, I wanted to say I work with text, but unlike Amber, already here, I want to say originalism makes total sense to me, right? To the idea that there is an intention when one writes something, and that this intention should factor in the interpretation, makes total sense. Whether that should be the begin all or end all is another question. But it seems to me that partly what your paper was pointing out is actually two things. One, judgment requires method. And then, okay, is method a neutral tool? Or is the choice of method already ideologically pregnant? That's one question. But the other is, whether the method is good or bad, there is also the question of bad faith, and you mentioned that. So maybe originalism as such is not entirely implausible, at least to me not. But partly I think what you were pointing out is that there is a bad faith originalism that invent fake news, propaganda, invented facts, and so on. And maybe we want to be distinguishing between these two things. One just last thing. The open constitution, or the living constitution, it's not without its flaws.
Absolutely.
And coming from a Soviet type experience, I can go on this, but one should think about, maybe as Aristotle did, that every virtue has two vices.
Well, those are both excellent points, but let me deal with the first one first. Yes, are there good faith originalists? And I think there are. Some in particular, particularly around the question of Brown v. Board of Education, actually. There was a lot of criticism of Bork and others because they said, you guys are against Brown v. Board of Education. And so beginning sometime in the early 90s, a number of, you know, quite really smart originalists started defending the Board of Brown v. Education on originalist grounds. So originalism in itself is not necessarily going to lead you to a terrible, terrible conclusion. It's just that it is so easily manipulated, and the people who take it in that direction can do so. You can argue either way. But as a method, it's not open to a democratic solution or democratic decision, it seems to me, because it's tailor-made to come to a prearranged conclusion, you know, if you don't watch out.
So is this then a very historian-resistant kind of conception of history?
Historian, yeah. I mean, it's completely anti-historical, right? I mean, it may be very textual, but it's not particularly historical. No.
But don't you, as Rainey said, have the same problem if you try to talk about the spirit of the laws?
Of course you do. Of course you do. But you're always constrained by judicial precedent. I mean, you don't. It's not anything you say. You can't just say, "Ha ha." I know. I feel that this is what what they had in mind, or what the Constitution should mean now. You know. I mean, they got into trouble. There was some real trouble around some of the privacy stuff, and you know, the penumbra of rights around the Bill of Rights. They probably pushed too far in that direction, no question. But nevertheless, you know, there was still what to put it, things would change over time, but you weren't being arrested by this very radical idea that I think originalism is. You know, there's always going to be a waxing and a waning and a difficulty and not. But the idea that the living Constitution is basically normal jurisprudence, as far as I'm concerned. I mean, it's nothing that James Madison didn't imagine happening, right? Which is that we're going to, they did it in their own secret. They didn't want anybody to really know what they were doing. Madison only released his notes so that you can try to figure out what their intentions were in 1840, that was not, their intention was not to be originalists. That was not what they believed. They believed that times change, things change, the law would adapt to those changes. Now, did they have a handbook for doing that? No, of course not. But they did rely on the idea that good faith judges would move ahead forward. And they were going to disagree, no question. But this is very, very different.
Well, thank you, Sean, for a great paper.
I can't avoid wondering if, on the 250th anniversary of the South African Constitution, whether there would be a comparable debate about this. But this is perhaps something, unless Albie has something very quick to say. He probably does, yeah.
Please. Where's the mic? Mike.
Yes, I was one of the original intenders. And our original intent was the Constitution should be a living tree. So if you follow the original intent, it means it must grow.
Exactly. Well, and Madison as well. You and Madison are the same camp.
Right, and when it came to interpreting the Constitution, I was there. I never used my inside knowledge of the debates. It's a public document, and that document takes its place in our history, in our pains, our hopes, expectations, and you develop a kind of collective interpretation, not dependent on what each of us had in mind. It underwent so many interpretations anyhow, you can't even remember what your original ideas were, even if you tried. It's actually been very painful to see what's happened with the Supreme Court. When I was a young student, it was in 1954, Brown Board of Education became a kind of lodestar for the role that the court can play, seeking out the law as a source of certain basic fundamental themes of humanity, and moving against gross forms of obvious, blatant, painful, hurtful discrimination. And I came to the States in the 70s, and it was such an exciting time, and the women's movement was gathering, and civil rights was gathering, and I'll never give up the hope that we had then, because the conservative forces, and I'll just end with this, I actually had a lunch one day at the Supreme Court, and Chief Justice Roberts was a very gracious host. The cuisine wasn't up to much, but wonderful conversation. And one of the justices, I'm not going to mention him by name, but it starts with a P, said to me, first question, would you say the South African Constitutional Court is an activist constitution? And I said, yes, Justice P. Justice A. Justice A. Yes, Justice A, but we have an activist constitution. And our constitutional text, as you can see, is very activist. It places demands to achieve justice, and he didn't ask any more questions after that. I happen to be also friendly with, surprisingly, a judge who shared my initials, AS.
How did that work? I mean, Ruth Ginsburg said she was too, but...
We were at a conference in Denmark. It was for the sesquicentennial of the Danish Parliament. So I thought sesquicentennial meant 600 years. And then I read an article about the sesquicentennial of the American Constitution, and I realized it was wrong. It's 150 years. And we were brought on board as the two extremes. He was the right wing, minimum interference by the judges, leave it to the democratic institutions. And I was the one speaking about fundamental rights being infused into parliamentary action. I think the Danish were more responsive to my side, but I was very amused. He rushed over to me afterwards and said, we both did rather well, didn't we? And he'd been a judge for a long, long time, and I was just quite a new judge then. But the thing I liked about him, and that made him even worse, was he was a brilliant writer. he used language well. We had that in common, that it wasn't just bringing out trite stuff. The sadness of it was these are brilliant arguments in favor of often very, very ugly outcomes. Well, it's a long, long, long battle. The US Supreme Court has changed over the years from being extremely conservative for decades, the whole crisis with Roosevelt, becoming very progressive. Now it's obviously very, very conservative. And I'll just end with this. When people ask me about judicial activism, I say, which is the most judicially activist court in the world? It's the US Supreme Court.
Yeah.
Absolutely.
It struck down campaign finance. Can you imagine? Both houses of the Congress, by a huge majority, on a partisan basis, aiming to defend what they know about democracy, and they strike it down. They struck down what the District of Columbia decided had to be done to control guns that were being used. So I was actually said that was the day I was invited for lunch.
Was that right?
And normally they would say, leave it to the local people. You don't have, and they invented this national thing against the text. And they struck down civil rights laws passed by Parliament. So I can't think of another court that's been more interventionist in striking down acts of the people who empowered the legislatures. And the real question is, are you activists on the side of power, of authority, of money, or are you activists on the side of the marginalized, of the people for whom don't get the protection from the political system that they're entitled to? We're all activists, whatever we call ourselves, and our court in South Africa has been activist for transformation quite overtly, and the US Supreme Court has become activist in exactly the other way. That's your choice, Americans. I'm not getting involved in that debate.
Wish us luck. Wish us luck.